On today's show, guest host, lawyer, and celebrated Cornell professor David Sherwin leads a discussion on the legal issues and controversies surrounding diversity, equity, and inclusion programming for employers. David is joined by lawyer Paul Wagner and also Holly Lawson, who is Chief Human Resources Officer at Noble House Hotels and Resorts, to look at how DEI training, once in vogue and now under fire, fits into workforce education, training, and development going forward. For employers, this is a critical and timely conversation that you won't want to miss. Check out the episode notes for more information about eCornell's labor and employment law and diversity, equity, and inclusion certificate programs. Here's David, Paul, and Holly on DEI and affirmative action for employers.
We're here today to talk about DE&I. And when we talk about DE&I policies and programs, we can look back to 5-7 years ago when the concept of ESG came and DE&I was part of that. And the argument was that companies had a moral and an ethical obligation to do more than just seek profits, and that diversity, equity, and inclusion was something that employers should be doing. And it a lot of momentum behind it, and there was a lot of positive feelings about DE&I policies and programs. A couple things happened along the way. First, there are legal issues. Second, there was a backlash, and DE&I went from being something that people just accepted and lauded to criticized and arguably is the cause for all the ills of the world. A bank in Silicon Valley goes down, DE&I. The bridge in Baltimore, DE&I. And while those arguments sound somewhat silly, it's still out there. So now, as we move forward with these policies and programs, the question for us is, one, lawfully, can we move forward with these policies and programs? And then two, if so, what do they look like? How should they be implemented? And do they work? So before we get to that latter part of how they, do they work and what should they look like, let's kick off with the law. So, Paul, in the Civil Rights Act of 1991, Congress amended the law to basically codify what we used to call the mixed motive form of proving discrimination. And they defined what the burden of proof would be for an employee in the mixed motive standard, and then what the employer's burden is, and kind of played some games with the damage scheme. And I will contend that the mixed motive standard, when applied to DE&I programs, it is certainly applicable and somewhat difficult with some of these programs for them to stay lawful under it. So can you explain first what we mean when we talk about the mixed motive and what the plaintiff's burden is, the employer's burden, and how it pertains to DE&I?
Sure, Dave. Thanks. And thanks for having me here today. So the 1991 amendment, and I want to talk a little bit about why Congress amended it then, because I think it's a very different purpose than is now being applied to scrutinize DEI programs. But we'll get to that in a second. That amendment took the burden of proof, or the standard of proof, from race or another protected class being the motivating factor, or the but-for causation, to simply a motivating factor. They significantly lowered the bar so that if an employer made an employment decision and was influenced by a non-discriminatory, non-protected class-based reason, such as disciplinary action by the employee or something on their resume that caused them not to hire, but the plaintiff could show that race or gender or religion or any other protected class crept into their decision as simply an element, it was still made unlawful. And so in a moment, we can talk about the application, the modern application of that to DEI, which is exactly where the opponents of DEI are going to go. But the reason Congress did that in 1991 was that they wanted to encourage lawyers to take these cases, even where the employer had a legitimate reason to take the action. If the protected class had anything to do with it, they would still get their attorney's fees in the case. So it was a means to encourage counsel on the plaintiffs within the plaintiff's bar to take these cases knowing that they were going to get paid, even though race or gender or whatever wasn't the motivating factor for the decision.
So two things, because you made the comment they'll get paid, and that's key, because when they amended the statute, they said that a motivating factor resulted in the employee's attorney getting their costs and fees paid, even if the employer could prove that they would have done what they did regardless.
Right. And so the employer gets nothing out of it, but his or her lawyer would still get paid. Again, it was an incentive for plaintiff lawyers to take questionable civil rights employment discrimination cases, knowing that they would still get paid as long as they could prove simply a component of the employer's decision was a protected class discriminatory intent.
And this is what I think confuses people. Let's go back. This is 1991. Let's go all the way back to 64. 1964, we passed the Civil Rights Act of 1964, and the purpose is to open doors. It's to open doors for women and underrepresented minorities. And now we move into, the 21st century and sort of the ends of the teens into the 2020s, and we're saying, okay, the next level of what happened and what was the motivation of 1964 is diversity, equity, and inclusion. How can the law that was supposed to open doors, and that's its purpose, for women and underrepresented minorities, be used against the logical extension of the law, which are DE&I policies?
It doesn't make any sense at all. However, you always have to look at the language of the statute and the bases for court decisions, including Supreme Court decisions. My opinion is you can trace it back to over-aggressive DEI policies of employers in the 80s, 90s, and 2000s. Perhaps as written, they were lawful or arguably lawful, but as implemented and interpreted by the person in the interviewing room making the decision, if they had a DEI policy that was encouraging the hiring of underrepresented groups, whether it be gender, race, et cetera, that they took that and interpreted that as a mission to choose that underrepresented candidate regardless of how they stacked up against the other candidates. And so that is a large part of why we see the backlash today, is there's lots of examples of what back when we were getting out of law school in the 90s was called reverse discrimination cases. Of course, there is no such thing. You either discriminate on the basis of a protected class or you do not. There shouldn't be a case called a reverse discrimination case.
And that's the bottom line. There's no such thing as reverse discrimination. It's just discrimination. And the statute says if sex, race, color, national origin, religion motivate you, it's unlawful. So Holly, you as a SVP of HR, somebody who's real active in the HR world, again, every year at the conference, we have you in a plenary session discussing the HR issues that are flying around. You have to have seen numerous DE&I policies. And have you seen some that reward different folks at the firm for diverse hires? Like, have you seen those kinds of things out there? And when you're looking at these types of policies, a super compound question, when you're looking at these kinds of policies, what's driving you? Stay lawful, be effective? What are we thinking?
Yeah, I'll answer the first part first, and then I'll kind of get in our programming and how we've structured our committee over the past couple of years and the years to come. But to answer your question, are we seeing that? Yes, I think as we have these active conversations amongst all of our colleagues in the industry and our HR leaders, it does feel that a lot of us are at different levels of this process and are going about it different ways. And I really enjoy and appreciate the conversations from my colleagues of where they are and what they're doing, and taking note of those that are kind of cutting edge in some of their processes and procedures. But I think there are some that are making more public declarations of their measurements and what their goals are and what year they want to achieve that. And I think it's great. We're not there right now in kind of our growth from a DEI perspective. Where we started out, we really wanted it to stay true to who we were. And I think if you create these programs from a place of fear, from either, legal backlash or internal backlash or external backlash, you're not going to really get to the core of the importance of the program. I think we've sort of built this brick by brick in really kind of establishing and sticking to our core values and what was important to us. We're still a family-led organization within hospitality, which is, I think, very rare in our industry. And we see ourselves as a family. And we think as a family that inherently is inclusion. We want people to feel included. We want to create a culture of inclusion. We believe we've always done that. We just put more of a voice to it and more of a definition to it. So last year, in really firming up this program, it was really more conversational and more training-based and more discussion-based. We had set topics for all of our locations to discuss each month. We had property committees. We had quarterly calls with the property committees to kind of gain their learnings and had some really great just initial discussions to come about. This year, it's more goal-oriented and action-based. So we are putting more of an emphasis on, diversity in recruiting and representation at leadership levels and representation in our partners and our vendors and being conscious of that. So it's more action-focused this year based upon the discussions that came up last year. Next year, we want to get to a place where we start to measure that more. And maybe that will become the point. Maybe this is where Paul can kind of poke holes in our process and say, here's what you need to look out for. But we really do feel like our true north is having always had a culture of inclusion and leaning into that. And I don't want to proceed with any fear of repercussions of that, because we think that the intent and the trueness behind that purpose is what we're really leaning into.
So thanks, Holly, because that it lays out exactly what a company is doing in a process. And now I kick it over to Paul and say, Paul, again, if Holly had said, our company's mantra is that by 2030, we will have X percent of this, X percent of that, in each category, you'd be somewhat concerned. I've seen, again, these policies where bonuses are based on diverse hiring. When we think about the whole DE&I process, we can talk about hiring, and then it's retaining, and then hopefully promoting. What are your kind of guardrails of what scares you in the hiring, and then what allows you to facilitate the program in the hiring? So what's kind of your good and your bad?
Let's go back to, you described what would normally be called a quota. That's always been unlawful, except in very narrow circumstances. If you were a judge to have violated Title VII and you were under a consent decree, that consent decree may require you to hire more as a quota people in an underrepresented group that you had discriminated against. Absent that, quotas have always been unlawful since the Civil Rights Act of 1964. They weren't scrutinized as much, and plenty of companies had them over the years. So that's always been off the table. I think the problem with the current climate is, and if you look to, and I know we're going to talk about the Harvard and the UNC case in a second, but if you look to some of the language of that case, both the majority opinion and a concurring opinion by Neil Gorsuch, the current conservative bloc of the Supreme Court is looking for, even where a protected class such as race is used as a plus, it's not the definitive reason for the decision, but it's an element or a consideration. Well, that sounds exactly like a motivating factor.
You're saying if you use it as a plus, Gorsuch is saying that's problematic. And to your point, it's a motivating factor. We'll get into a little bit more detail about the difference between Title VII, 14th Amendment, and all of Harvard, UNC. But so let's go back. So if I said at my company, I'm going to give Holly, the senior VP of HR, her bonus is based on 5 things, and number 3 is the diversity of those that are hired in this last 12 months, you're going to say, that sure looks like a motivating factor.
It certainly could be. So the devil will be in the details. That's going to be used by whoever is going to be scrutinizing the employment decisions made, and it would likely be someone who was not hired, who did not fit into those categories of diversity that Holly was encouraged to select from. And that person would say, aha, you had a financial incentive to pass me over and to pick somebody in one of those protected class categories. And you, in fact, did that. Now, Holly and the company can still defeat that case if they can show that, well, yes, I had a financial incentive to do that. The way in which I went about it was completely lawful under Title VII by simply looking at our recruiting platform and our recruiting strategies, realizing that we were recruiting from very traditional sources, and maybe we needed to look out to look to non-traditional sources.
You're talking about maybe potentially what you can do that is not unlawful,
right?
And we'll get there in a second. But I'm going to push back on. I don't know how you can defend a policy when they have Holly on the stand and they say, so X thousands of dollars were on the table for you if you didn't hire my client and you hired somebody else. And you're saying that didn't motivate you at all?
It's a tough one. And by the way, we're all in the hospitality industry. Most of the people we hire, we're looking for a relatively intangible, subjective, leadership ability, service ability, eye contact. I mean, the soft skills that we value so much in hospitality. It's very easy for an interviewer, and Holly, if she is that interviewer, to say, oh, no, I got the best feel from that candidate as opposed to your client. And the response on cross-examination is, the feel was you weren't going to get your bonus if you hired my client. Right. So it's very problematic.
Yeah, right. You felt good because you just qualified for your bonus. So Holly, knowing that you don't have a policy that says you're going to get a bonus based on, we hope you don't, based on your diverse hires. So when you're looking at hiring, Paul started to allude to it, but since Noble House is strong in its DE&I policy and wants to ensure a diverse workforce, from the hiring standpoint, what are you doing to get there without creating a policy that's so problematic and easy to attack?
Yeah, I mean, I think the process of diversifying our recruitment became very organic for all of us, right? Like, especially hospitality struggling out of the pandemic and reaching out into every possible well to get more talent. It became pretty organic for us to align these DEI efforts with that need to have diverse talent. And again, I go back to, what's your purpose? What's your reason for doing this? That was a specific message somebody had at one of our HR and hospitality conferences in the past. If you don't know why you're doing this, then don't do it. So if your specific purpose is understanding that, and this has been a message since I joined hospitality, if we inherently have diverse guests, we feel we'll connect better with them and having diverse candidates to service those guests. And as Paul said, it's often the intangible, it's often the unteachable. We're a gritty industry, grow from within, work hard, and it pays off for these sort of things. So I think that opens the door for us to consider a larger group of individuals. And many of us, as I said, have just been encouraged, and in some cases really have had a necessity to expand those channels and get creative and look and tap into different areas that we hadn't before. And that's really served us well. So I don't proceed in any of those directions feeling any sense of caution or concern that we're breaking any rules or that it's going to get scrutinized, because it's the right thing to do. It's the necessary thing to do. And it's creating an environment of others, seeing a sense in themselves. And even with promotion decisions, I have a gal sitting in a couple offices over from me that we just promoted internally, a Hispanic American female. And, I'm so proud of her. And she's been a big champion of our efforts. And I said to her, she said she wants to use this as a continued platform for championing the message of DEIA. And I said that the beautiful thing is we have so many people in our organization that see themselves in you and now know that they can raise their hand. This is an organic, lovely thing that happened coming from a good place. She worked hard, and now we have an opportunity for others internally to see themselves in her, recognize that this is a possibility for them, and we want to continue that. But I don't fear any backlash from that, because I think it comes from a really good place.
So, Holly, you talked about channels and opening doors and so on. Can you give us specific examples of where you would say that we weren't doing that, or policies that don't allow that, and then policies that do? And then after Holly goes through kind of the dichotomy between kind of the before and after, I'm going to ask Paul to analyze that legally, what she's saying they're doing now. So, like, when you say opening these doors, what are you doing?
A lot of us within hospitality are having more of a focus on historically Black colleges and visiting just a larger network of campuses, other minority campuses in general for college recruiting. The refugee organization, there's a great organization called Tent that was started by the founder of Chobani that really has a high emphasis on assisting refugees and getting them lawfully working here. I think a lot of us had those community relationships before, but leaning into that more than ever. So I think there's just been that continued conversation of where were we not looking before? What were we not thinking of? Where were we not going? And how can we really get some amazing talent out of those partnerships and opportunities? And it's been amazing to just see more and connect with more and feel welcomed within those situations.
So, Paul, any issues with that? And is that similar to what you advise your clients who are implementing these types of programs and policies?
As described and presumably as written, no. As implemented, that's again where the exposure occurs. Because if you have a DEI policy that encourages the achieving, and hopefully it doesn't have a set level of diversity in traditionally underrepresented groups, but encourages that prospectively, and you turn that over to a series of interview teams, you go to the trouble, as Holly has described very well, of opening up your potential sources of applicants to non-traditional sources with the goal of attracting qualified applicants from those groups. So all of that's great. All of that's beautiful. But when the interviewee walks in, the interviewer rather, that walks in from the company, knowing that diversity policy is set up to attract qualified minority applicants, for example, and has the choice between a minority applicant and two that are not in those groups, and tips the scale because that interviewer knows that the policy is encouraging that. Maybe not a bonus, as you hypothetically described Holly having, but they know that's the goal of the policy. So what you have to do as an employer to withstand the scrutiny, and by the way, just for the record, I'm highly in favor of these policies. I think they make sense, and I think they've done a wonderful thing to our industry, hospitality, and many other industries in this country. But I also want to see them survive the scrutiny that's coming, and it's going to get worse. So what do you need? You need very careful, meticulous records and notes to be able to prove that I went out there, I expanded the opportunities for some of these underrepresented groups, I brought in qualified applicants, and I'd hired the best person among the group. And one of your great lines that you've used many times, there's never the best person, right? So you also have to think through strategically, like, how do I show that among these three, this person came out ahead, maybe by a nose, but came out ahead.
Right, and that is the argument I always use, and we talk about with the Supreme Court when they said you need to pick the best person. And I'm like, there is not one person that is the next best Supreme Court justice. There's 1,000, and it's just what the timing says, and there's a gazillion different factors. But we've got several questions, so I'm going to play a new game here today. And the game is, we've got several legal questions. So I'm going to read it, I'll answer one and ask you if you agree, and then I'll read it, you answer it, and see if I agree with our...
Game on.
Game on. Here we go. We have a question from Karen. She says, are you saying that the change in the laws was to benefit employee attorneys versus an incentive for attorneys to take cases that would never otherwise get a hearing? And Karen, I would go with the latter comment that you made, and I think that's what Paul was saying before, is that The Civil Rights Act of 1991 gave cost and attorney's fees when the employee could prove that the protected class was a motivating factor. And that was in part, in many situations, the plaintiff's lawyer is the gatekeeper that is going to say yay or nay to this case. And by making the attorney's fees somewhat easier to get, it would open the door for lawyers taking the case. And that was one of the reasons behind that part of the Civil Rights Act of 91. Paul, agree or disagree?
Oh, totally agree. And Karen, forgive me if I did not articulate that correctly. Absolutely. The attorney is being incentivized to take the case, even if his or her client doesn't get any financial compensation out of it, with the ultimate goal being eliminate discrimination in employment. That's the social policy of the changes in 1991. And think about 1964 and the Civil Rights Act. The clear mandate there was we have gross discrimination, horrible discrimination in employment. We're coming out of the still lasting effect of the Jim Crow laws in the South, some which still persist to this day, by the way. And it was to eliminate discrimination in employment in favor of those groups for whom there were documented decades and decades of discrimination.
Well, and that kind of dovetails into the next question from Carrington, who says, was the law to protect against discrimination or discrimination against those classes that were historically discriminated against?
The latter, for sure, because of, if you look at the civil rights movement in the 60s and beyond, it was clearly to address the victims of that discrimination. The way the law was written, however, it was not written in a way that said only the groups that had suffered from historic discrimination are actionable plaintiffs and have standing to bring a claim. It said any discrimination. And so, like many laws, the drafters of the law may not have seen into the future to see what we're dealing with today, but it protects all of us, whether we're in a traditionally underrepresented or discriminated against class or not.
Yeah, I agree with you completely. And I think that's, if you look at the law, the purpose of the law is clear. In 64, it was a way to open doors. Doors were shut. Doors were shut by law. So this was a way to open doors. And it was not the way it's being applied in this conversation. But the law is written as for, I guess, the goal of a colorblind society. And that's how the law is written, and that's how it's applied. And it started with that Bakke case where somebody's trying to get into the University of California, Davis Medical School in the 70s, which we beginnings of so-called reverse discrimination. So the purpose and its application, not really the same on this part of it. The next question comes from Denise, and Denise says, we know the data shows that organizations that have higher levels of diversity have better performance outcomes. How does that play into the legal defense of having policies to create diverse workforces? I'll answer, and then Paul, run it, see what you say. That is not a defense, because there's a lot of law with Title VII that says Title VII is about the individual, not the class. So if you were to say, and all that, and I agree completely with Denise's description of what the research says, and it's true that diverse workforces have better outcomes, but the law of Title VII is not, it would not be a defense to say this diverse workforce is better, and that's why we hired person A over person B to get there, because person B is aggrieved. And that's what Title VII is about. It's the individual, and it's not a defense on the class. And Connecticut versus Teal gives us that in the adverse impact situation. So do you agree or disagree?
So I agree with both points. Point number one being agreeing with Denise that the research does show that, which, by the way, is why so many companies, I would say a majority of your public companies who have come out in favor of DEI and are willing to show that data, it does show a great workplace culture, cultural benefits, productivity benefits, et cetera. I also agree that that's not a defense to a Title VII case. And we saw that signaled in the Harvard and UNC case, although not under Title VII, that these claims and these rights are individual by nature.
And now I'm going to go to Holly on this one. So Mary says that she thinks the conversation is focusing on hiring diverse talent as some sort of charity work. DEI programs are meant to hire qualifying candidates, and diverse candidates do qualify and belong. And I guess my take on that is absolutely. And I think that Denise's comment shows us exactly that we agree that all the studies show that a diverse workforce is a better workforce. So it's not about, I don't think it's about charity. I think the argument is it's about success for the company. So Holly, can you comment on that?
Yeah, I think that's spot on, nail on the head. I mean, again, going back to the reasons why you do things, I think that we're not trying to say, like, look at us, we're doing these great things, look at us, we're recruiting all these different ways and advertising that for a pat on the back. It inherently yields the result you're looking for. And I think another way that I've described it in our process and what we've sort of, again, building it brick by brick, what's been important to us, we've sort of focused on the inclusion part in order to gather the diversity part. We want people to feel included. We want them to tell others about our culture and that they feel included and just sort of naturally and organically bring others in who see themselves represented and continue to contribute to that, because it's just, it is the right cause. It does create a higher performing culture, and it's not for any sort of accolades or pat on the back or a box to check. If that's your intent and your purpose, I think people see through that, and you're probably going to work backwards in your process.
Dave, may I respond to
Please.
that? To further Holly's point here and to pick up on the characterization of a charity case, my point of view on this is that the culture war scrutiny mostly from the right of DE&I programs accuse them of being a charity case. That's the way that group describes them and how it attacks them and uses that as and an undeserved one, by the way. But completely agree with Holly on that these have great value. And the comment by the audience member, of course, the goal of these programs is to reach out to, attract, and ultimately hire qualified candidates from those underrepresented groups. And if we do that under a modern DEI program and have the evidence to prove we've done it, we're still okay, despite the accusations from the right saying that this is a charity case or somehow unlawful.
I have two more questions, and it's great to get these questions. I'm going to answer the first one and tee up the second one for you, Paul. Chuck says, does the law now protect against discrimination based on membership in combinations of protected classes, original meanings of intersectionality? And I would say that the law is way behind intersectionality. The law is very binary in how it's written. When they talk about sex, the courts have over and over said that sex and gender mean the same thing, and they talk about disparate treatment between men and women, and the concept of non-binary is not there. And when you look at intersectionality in terms of race, religion, and other things, the law was not written with these things on the table, and now has to deal with it in some ways. And there's a whole bunch of law prior that kind of conflicts. So this is a time that we're seeing change, and we'll see how the courts address it.
I agree with that to some extent, though I would say that a lot of discriminators out there discriminate intersectionally.
No, I think that's true. It's just the law is not there for them.
And if you can show that a combination of factors was a motivating factor, getting back to the mixed motive standard, it does establish a cause of action. It's just gathering and presenting the proof necessary to do it. But you're right that, like many things in society, the law follows cultural maxims and evolutionary standards. And I think this is another example.
And then the other question, and this is somebody, Muslima, saying, be careful, the Harvard-UNC case did not deal with Title VII. It dealt with the 14th Amendment. And of course, he's right. And I think that what we want to get across on that is Harvard-UNC looked at the 14th Amendment and that's what it based its decision, that race cannot be a factor in admissions. We have an executive order for affirmative action, which requires employers with $50,000 or more of government contracts to have affirmative action policies, which would be using race as decisions. And I think we both believe that based on Harvard and UNC, the 14th Amendment would say that would be unlawful if it came under scrutiny as a government action. And that Title VII, as interpreted, would be the same because, again, we would be using this as a motivating factor. So Harvard and UNC use the 14th Amendment, but kind of the theory goes to Title VII, and the 14th Amendment could be used to knock out the executive order that is affirmative action.
Absolutely. And you went through a very legalistic academic path to get where you landed.
It's my job.
I'm going to make it a lot more simple. Read that case, including the concurrence by Gorsuch. There, the majority, and Gorsuch in particular, are waving a big old flag at all of us saying, Title VII's coming next. Trust us on this. We've studied this. That one of the sort of the inspirations and genesis of this discussion is our, many discussions on this. And so if you peel back the strands of that decision, that is going to be the next step. And look what happened in the wake of Harvard UNC. How many other cases have been filed citing Harvard UNC to apply it to DEI programs as unlawful under Title VII. In fact, America First Legal, I believe, is the not-for-profit led by Stephen Miller, who some of you may remember from the Trump administration, that filed a myriad of complaints against over 20 Fortune 500 companies, accusing them of violating Title VII directly by their DEI programs for the reasons set forth in Harvard UNC. So this was a clear warning shot to employers, even though it was in the academic context in the 14th Amendment. And we're already seeing the test cases that in the coming years will be decided by federal courts and perhaps a case before the Supreme Court. So that's what we're worried about.
And we've got about 20 minutes left, and I want to shift gears a little because we've gotten legal geeky through most of this, and we've talked about hiring. Holly, when we talk about after hiring, retention, promotion, I have two questions. What do you do? What does it look like? You've said that you're in a step-by-step process. So, where do you see it going? And then how are you dealing with this backlash? In the intro, I brought up the fact that we've seen DE&I policies blamed for pretty much anything that really doesn't have much logic to it, but it's out there. It's out there in the media, and your employees in a country that is, 51-49 or closer, I can't imagine that all your employees are on the same page with something that's become so controversial.
Sure. Yeah, I guess on the first question, to start there, I've mentioned a lot of our recruitment efforts, but as far as the development of talent, we're certainly formalizing a more structured performance management program internally and focusing on our high performers. And there is an intent behind that to make sure that there's representation amongst those that we're identifying and wanting to grow. There's some amazing resources through AH&LA of apprenticeship programs and training programs that we really are trying to partner with and lean into for some of those high potential individuals. And the person I spoke about earlier just got a scholarship into one of those programs. So just the encouragement of that, the education of it, the advertisement of some of those opportunities to identify the talent. We have a lot of longevity in our industry or in our company. We have a lot of people that have stuck around for decades. So we are really focused on growing that next generation, understanding what that generation looks like and kind of who to tap into and who to really foster and grow over time. So that's sort of our current intent in the process. But on the question on the backlash, even on this call, I know there's quite a few people that had RSVP'd for this. I realize that just statistically speaking, there are going to be people listening that are shaking their head that we're doing anything at all. I know statistically speaking, there are people shaking their head thinking that we're not doing enough and that we should do more. That's the reality that all of us employers are in right now. If we don't have an identity and stance and kind of ethos behind why we're doing this, then that's problematic to some people. If we say anything or do anything at all, then that's problematic to some people. But just again, going to the intent, we want to stick with our process and we want to stick with fostering that growth for those internally because we believe in them and we believe it's the right thing to do. And we believe in having a true intention behind that. And you just can't proceed with fear. And the other thing that I haven't mentioned enough, that you have to have a unified front at the senior leadership level too. You have to know that if you have that partner or vendor, I've said I haven't felt a lot of that backlash internally as much, but I recognize that people internally may be more reticent to speak up if they do disagree with what we're doing. But we have seen that more vocally from partners and vendors and others that we've worked with that just don't agree with it. And we have to respect that too. And our line has kind of been everyone has choices. And this is the choice that we've made. And we have the support of our senior leaders within this organization, and we're going to stick to it. But I certainly feel the differences in having a high concentration of properties in Florida and a high concentration of properties in California. There are differences felt in the rollout of this. There are differences felt in the scrutiny or embracement of the conversation. And you have to recognize that and understand it and navigate around that and not push anyone to a place of discomfort. Our committees are also not a mandatory program that everyone has to participate in, and there's repercussions if they don't. We want it to be participatory. We want it to be individuals that want to be involved in this. And otherwise, again, it's not a genuine program. So keeping it as that, you're inherently going to draw people to the table that really want to be there, no matter where you are in the country.
And Holly, when you look at these types of programs, and this is, again, you're working for a company and the company's putting resources behind this, they want to see if it's successful or not. Yeah. They want some data to measure it. So is that true, or am I just making this up? I mean,
100%. And one of the ways that we've seen this show up in our industry, this is the first year I've really felt this in a more prevalent way. We have to partner pretty closely with our sales team now, because when it's RFP season and they're getting all these requests for proposals from prospective groups and partners, they want to know in a lot more detail than I've ever seen before. To your point, what is our program? What are we doing? And so we have an outline. We've shared that openly with anyone who's asked, even outside clients and customers that have asked the question. I've provided our sales leaders with that. And some have come back to say more, we want more and tell us where this led to. And we have to be honest and say, we're a discussion-based program. And, this is sort of high level what we've done, but we're not at a point of giving like metrics and measurement. We're not there yet. But even if we did, I don't think it would be something we would be releasing to prospective guests. That it is being requested at this point. It's been kind of incredible to see.
So, Paul, when you hear that a company has implemented a DE&I policy or program, and that that they have some measurements, are you concerned about measurements as evidence for some lawsuit down the line?
And when you say measurements, Dave, what do you mean?
Well, they're now saying that they've put together their workforce in 2020 was X percent this, X percent that, almost like in an EEO1 form by putting everyone by race and sex and so on. And now they're comparing that and contrasting it to 2024. And they're now sending out a memo that says our DE&I policies are working great. Look at the difference in our workforce.
I'm less concerned about that than the prospective goal that you see a lot of companies were making 10 years ago, 15 years ago. A publicly traded company, the board of director announcement that our goal within the next 8 years is to have 50% female representation at all leadership positions, VP and up. That was very problematic because unless, as I said before, you have all of the documentation and evidence to show that despite that goal, you still interviewed everyone and picked the best candidate or among the best candidates.
And we've discussed there is no best candidate.
There is no best candidate. I think retrospectively to say, hey, look at what we've done, and we did this through an organic, a very substantive DEI program, and we're proud to say that we've reached a level that we can be proud of.
So
now, can that still be used as evidence for the person that had already filed their suit or was going to sue for a decision that was made in the last few months? It could be problematic, again, just depending on the evidence. But I think companies also have to ask the question, and Holly alluded to this a couple of times in very persuasive fashion, what do we stand for? And if we stand for this and this is a goal and we're going to put it as a priority, then, bring on the litigation, bring on the scrutiny, and there are things you can do to weather that storm.
And so you would look and say, if you didn't have a goal per se, but you said, we do believe that a diverse workforce is a better workforce, brings different ideas to the table, different life experiences to the table. We stopped looking at just the same 3 colleges or 4 high schools or whatever it is, and we broadened our pool and we broadened how we advertised and so on, and check out our workforce. It's changed significantly and we're better for it. That doesn't sound as prima facie evidence.
It isn't, but again, the devil will be in the details of how those decision makers at the property level, at the interview room table level, make their decisions and encourage others to make their decisions. I had a case recently where an employer had what would otherwise be a completely lawful, even under this stricter scrutiny that we've been talking about, DEI program. But the person who was the head of personnel for this company, who was the leader in every interview of any managers and up to senior leadership positions, would say to the other interviewers who are also participating in the decision, oh, no, we have a minority candidate. You have to choose that person, irrespective of their comparative qualifications. And so obviously that's a very distinct situation, yeah. But there's a lot of situations not as extreme as that where that evidence is used. So my point of view is that, pick who you choose what you stand for. And if you stand for that and you're committed to it, understand how that scrutiny is going to come at you and build the right defenses and the right structure to withstand the scrutiny of your own programs.
Which makes total sense. And I've got a question from Renee that goes right to Holly. So Holly, given that diversity and inclusion involve embracing a range of voices and experiences, how do you, Holly, believe we can ensure that discussions and decisions on DEI initiatives are genuinely inclusive and representative of all the communities, especially those historically marginalized?
That's a great question. Thank you. I fully believe in crafting your message in the way that you're disseminating your policies and practice and generating the discussions at the property level. As I mentioned before, since ours is an elective, I basically said I do not necessarily want my HR people to drive this program because I don't know. I believe I have a very diverse HR team, but I don't know if that's the most diverse representation within our company. So by opening it up to allow voices to speak up, that has brought forth more minority individuals to be part of that. I've tried to step back in this conversation quite a bit to my colleague, Carmen Sanchez, to let her kind of be the voice that at our internal conference, I wanted her to speak on it and not me. So you do have to sort of intentionally allow that space for others to speak up. And at first we did grapple with the decision of, do we ask certain individuals to make it very specifically diverse? Do we invite certain individuals? And in some cases we have, and in some cases we've said, let people speak up, even if they may be a minority that doesn't want to champion this message or be part of the message, or maybe they want to stand back and wait and see what happens. So we've been intentional to create some space. We've been intentional to draw some people in that we really wanted their voices to be heard. But that's a great point. And I think the success of your program really does hinge on having representation of your voices that are championing this message.
Thanks, Holly. I'm going to go back because Andre has a question, so I'm going right back at you. And we're talking about employee resource groups and programs. And Andre says a lot of organizations focus on developing ERGs. I'm curious how employee resource group programs play into all of this, especially if individuals ask for a, in quotes, white ERG. So do you have ERGs, and how do you deal with it from your, how do you deal with it at Noble House? And then I'll ask Paul quickly on his clients.
Sure. Yeah, we don't have subsets of ERGs right now at Noble House. I have had that in some of my past companies, and it went really well. And again, those individuals led those groups that felt passionately about that, whether it's a women-led group or an Asian-led group. So I've seen success in it. We haven't rolled that out to that degree here. I think our subgroups are around different kind of employee cultural topics like community involvement, like our green initiatives, like our diversity initiatives as well. What we have been cautious of is some of our properties have wanted to combine to have kind of one cares group that tackles all of that. And we've discouraged that where we can, because we want to maintain the integrity of each of those topics. And we don't want, there may be somebody in one group that doesn't necessarily want to be the conversation in another group. So we want to maintain the integrity of each of those topics. So I haven't had the last example be brought up to me yet, but we have really tried to keep people's focus on those respective topics so diversity doesn't get diluted with, I think there is inherently a part of community outreach and involvement that is part of diversity, but we do still see that as kind of a separate initiative and discussion. So that has been one thing that we've really tried to maintain.
So, Paul, do you have clients who are doing the ERGs, and what's your, what are the pitfalls? I've heard people say that when you do an ERG for one specific group, that can be seen as a problem for those excluded who want to be in that group or don't have their own group. So what do your clients do? What do you advise?
I really liked Andre's question, because I think that it shows the very thing you've just described, which is if you allow self-determination among employees to create the groups and become exclusive, we as human beings, we tend to be that way. We like to exclude others from our clubs. That leads to a lot of problems, and ultimately to what I believe Andre was referring to, like, wouldn't you see this as potentially a negative if someone said, well, I want a white only group. And yes, I would see that as a negative. So, I've seen a lot of very informal ERG policies at many of my clients, and some that are structured. I like the ones that are more structured and are more intentional by the employer, so that you are driving for maximum inclusivity. They can be specialized when it comes to certain things, like people that are interested in, the safety committee. That's sort of the original ERG, right? The employee safety committee. But when it comes to these issues of DEI, I'd recommend and much prefer one that inclusivity of anyone in the workforce is the principal maxim, so that you don't send that message. And I realize that also has some, negative externalities for perhaps a more exclusive group that could actually provide some amazing input on particular issues, depending on where you are. Perhaps a group that has historically been underrepresented, and there is a contingent of them there. So I think you have to really look at it with a critical eye of, how is this going to support my DEI program? How is this going to support my culture? And most importantly, how I'm going to get my employees to feel good about it, that we want them to participate in a positive way and not see this as, a series of little exclusive country clubs.
Holly, I'm going to give you a last word on where you are going or where you see this. And then I'm going to ask Paul after that to just give a last word on affirmative action, because I think it's a term that we overuse and misuse. So I just want to clarify it, that the listeners today have a good idea of what it actually is. So Holly, as you go forward with this, with your own policies and you look at others, just what's your last word?
I think last word is to really lean into the true reasons for doing this, as I've said. But I loved that last question and leading into allowing different voices to kind of guide your conversation as well. And that's been really important to us, bringing in outside voices, having different perspectives. As we've gone year by year in this program, I haven't known 2 years down the road what it will look like, because I want our actions to guide that. And I want to hear from other people, to hear what's working, to hear what sticks, and let that kind of guide our next steps. So, but I don't want to be marred down by fear. I don't want to be marred down by the polarized world we live in, where you're kind of damned if you do and you're damned if you don't. So I don't have any concerns or fear moving forward and progressing our policies, because that's how we're going about it.
Thanks, Holly. Paul, with affirmative action, I've heard people say we're an affirmative action employer, so we can hire, that this, quote, reverse discrimination doesn't apply to us. And my argument is always, wait a second, affirmative action is a requirement if you have $50,000 or more in government contracts, you have a history of a discrimination, and your numbers do not reflect that of the available workforce. And you can't just call yourself an affirmative action employer, and if you are implementing your policy, it's very structured and scrutinized, because your policy can't trample on the rights of those who you're not looking to reach goals for. So you've done affirmative action policies. They're complicated. Give us just a last word on how much you can rely on being an affirmative action employer with regard to DEI and Title VII.
If you analyze the criteria for affirmative action under the executive order that's administered by the OFCP, that's just a threshold question. That just identifies you as a company that needs to keep certain records. It's a record-keeping requirement. Lots more happens after that, which is you have to keep those records. If those records show that you are underrepresented in certain groups, you're obliged to take certain actions to remedy that. But those actions do not permit you to simply say, I can hire blind to the qualifications of the job. And when you look at the scrutiny that we're seeing today, I think the term affirmative action and affirmative action employer is unfortunately used as a sword to the forces that are scrutinizing DEI programs as sort of a dirty phrase, as a negative. And so the traditional affirmative action is to go out and hire on the basis of a protected class to
reach your goals,
to meet your goals, or to redress past harms.
And there has to have been a history of past harms.
Right. And those are two separate things, an affirmative action employer under the executive order and what you're talking about. Going forward, though, I predict that the executive order is going to be deemed to be also unconstitutional and contrary to the things we've been talking about. And I would encourage employers to focus instead on these DEI programs, because if designed correctly and monitored and implemented well, you're going to continue to withstand the scrutiny. You're going to win the lawsuits, or hopefully avoid them, knock on wood, at all costs. And keep in mind, as much as there's forces from the right in these culture wars attacking these programs, there's forces in favor of diversity and a multicultural society. I mean, look at all of the gender pay equity laws that are cropping up all around the country. Look at the law in Hawaii that was just passed effective this year. That's pushing through legislation that's coming at the opposite approach. So we may have painted a bit of a dire world at the outset. I don't see it as dire. I just want to make sure that my clients who want to achieve those diversity goals withstand the scrutiny and win at the game, because it is a game worth winning.
It's the perfect last words, game worth winning. I think as one of the questions was, the research all shows that a diverse workforce is a more productive and successful workforce. And there is some risk, but the companies that are trying to be successful are saying, we'll take the risk to get to that right result because it is better for the company.
It's where I want to work.
Thanks for listening to Cornell Keynotes. Check out the episode notes for information on eCornell's labor and employment law and diversity, equity, and inclusion certificate programs. Thanks again, friends, and subscribe to stay in touch.